Here we're going to talk about debtor and creditor relationships. When disputes arise over the amount owed, or when the debtor simply cannot or will not pay, what happens? Here we're going to discuss creditors' remedies that are available when that debtor defaults. Types of laws available to the creditor include liens, garnishment, suretyships and guarantees, as well as language that's found in mortgage agreements. We're not going to talk about mortgage agreements. We're going to talk about the first three here. What is a lien? It's a creditor's claim on real or personal property to secure payment of a debt or performance of an obligation. Liens arise in a number of ways, including a mechanic's lien, an artisan's lien, judicial liens, and tax liens. What is important about liens is that they generally take priority over other claims against the same property. Most instances, a mechanic's lien and an artisan's liens take priority over perfected security interests in property. So let's talk about these liens specifically. Mechanics liens, and sometimes referred to as material men's lien. This is completely statutory law. It was created by legislators. It's a lien on real property of another, created to ensure priority of payment for work performed. So for example, a contractor does home improvements to real property, like somebody's home, such as putting a new roof, or they build cabinets, and they don't get paid. The contractor can file a lien with the county office where the property is located. Then they serve a copy of the lien on the property owner, which gives that property owner notice of the lien. And the property or real estate becomes the security for that lien. Now what happens? You got that lien, it's filed. I'll tell you how it happens in New York State. There's probably some similar proceeding for other states, but in New York, a lien holder has 1 year to begin a foreclosure proceeding to force the sale of the real property to obtain payment. Otherwise, their option is to sue for a breach of contract, and then this would result in a judicial lien or judgment, which gets placed at the end of the priority line. Most people have mortgages securing their loan for the purchase of their home, and while this lien does take a priority, as I said, the contractor only has a year to bring a foreclosure action, and you still have to hire an attorney, and you still have to go to court over it. And if they were to do that, the mortgage company is going to step in because they don't want their lien affected in any way. Most contractors sue for breach of contract. Usually these amounts are fairly small. I mean, obviously they could be extensive and go through it, but a lot of the cases that I've been involved in, where somebody puts on a roof to a home or builds cabinets or puts up a shed, these small types of cases result in a breach of contract claim where the person can go themselves to a small claims court and get their judgment and attempt to get paid, versus the bigger and longer process of having to go through the foreclosure process. But certainly, if somebody's building a home or an entirely huge structure, and we're talking about something that is $100,000, that may be the route to go if somebody is not paid. The foreclosure route, that is. An artisan's lien is created, it's from common law. Common law created this. And this occurs when one repairs or improves personal property of another and retains possession of that property. The possession of it or retaining it is the security for payment of services. The lien exists so long as the lien holder maintains possession. Once the possession is voluntarily surrendered, then the lien ceases. So let's say Art has a mechanic repair his car. Upon completion of the repairs, the mechanic retains possession of the car until Art pays for the repairs. If mechanic releases the car before payment, then there's not going to be a lien. Another example, Selena leaves her diamond ring with a jeweler to have her initials engraved on the band. She's to pay when she picks up. the jeweler can keep the ring until she pays for the services. So what happens should she fail to pay? What if the ring is worth $3,000 and the engraving only cost $100? The jeweler has a lien on the property for the amount of the bill only. So if jeweler has to start a legal action, the court is only going to award the jeweler what it's owed, which is $100. The jeweler cannot keep the ring, the $3,000 ring. They would actually have to move forward. And a lot of folks, they just don't relinquish, the product until you pay for it, or your property until you pay for it. Tax liens. These are imposed by government to secure taxes. These liens are usually on real property, but any property they can get their hands on will do. With land and school taxes, if somebody owns real property and they're required to pay land and school taxes, these liens will take priority over any mortgage, but also not paying income tax. There's a little bit more of a process. It's not automatic as if it was real property, but there's a filing time, and to do that within a certain amount of days, and then it would ultimately become priority on any sort of against any sort of real estate or any sort of property tax liens. Judicial liens are the result of a court order or court money judgment. If a debtor is past due, creditor can go to court, sue the debtor for the amount of the debt. When they win, they get a judgment or a piece of paper stating that this is the amount that's owed plus interest and fees. The debtor has a period of time to pay it, and then that judgment turns into a lien to which the creditor can then file with the county where the debtor resides or does business. If the debtor owns real estate, this will attach to that real estate. So if the real estate was to be sold, the debtor is going to sell it. They would have to clear that lien before it could be sold. So the judgment lien is at the bottom of the priority collection chain. So if this was something that was attached to real property and the debtor was going to sell that real property, the mortgage would be first, and any liens that came before, they were perfected before the money judgment. There's a tax lien, another sort of lien. So this is going to be at the bottom of that. But there are avenues that the creditor can pursue. Before a judgment is awarded, the creditor can ask that any property of the debtor be seized. The court, when they say ask, they ask the court whether this property, they know that the debtor owns this property, here's the proof, and can it be seized to satisfy the debt should I win? Because this comes before. So if the creditor then wins, then the property is sold and the payment is gone to the creditor. If the court issues a judgment first, which is usually what happens in most of these cases, the creditor is going to wait until they have a judgment. So writ of execution is issued, in which the sheriff will go out and seize property and sell it. The court will issue an order for a writ of execution. You may have heard of an income execution. It's the same sort of concept. The court issues an execution, to which then goes to the sheriff, and then the sheriff serves it. But it attaches to the wages and earnings, or even the earnings of a trust. Any money that the debtor gets from that we'll call wages or earnings. Another concept that we have is garnishment. You may have heard of a garnishment. This is also court ordered. It's court ordered on a third party. The court orders seizure of money that's held or owed by a third party. So this allows creditors to seize the amount that's owed through direct collection from third parties from whom a debtor has money or receives money. An employer, a bank, where the debtor has an account. This varies from state to state. After a creditor obtains a judgment, they can request from the court an order of garnishment. You only need one per place. So you would need one for the bank and you would need one for the employer and anywhere else that a third party holds money on behalf of the debtor.